Hello, welcome to E-Pathshala, the course Legal Literacy. I am one of your course teachers, Maruk Aidenwala, a lawyer. The subject we are looking at today is human rights. We are going to discuss human rights in two parts. This module contains part 1. This module relates to the concept of human rights and the different stages the concept went through before it reached its present form. What do we understand by human rights? Human rights are the most basic and fundamental rights which a person is born with. There are three main characteristics of human rights. 1. Universal. 2. Inalienable. 3. Interrelated. What do we mean by universality of human rights? Human rights are applicable to all human beings. It doesn't matter where they reside, it doesn't matter what language they speak, nor does it matter what religion they follow. It is the same for all. Inalienability of human rights. Nobody endows upon us human rights. We automatically directly get them on birth. As human rights are not endowed upon us by any authority, no authority can deprive us of human rights. Interrelated. The development of a particular human right will result in the advancement of another human right. In the same way, the culling of a human right will result in regression of other human rights. For example, the right to shelter. If a family enjoys permanent shelter, they will be able to enjoy their other rights, such as education for their children and food for their family, as the security of a roof over their head will give them the ability to enroll their children in school and in the public distribution system. The term human rights has been coined by the United Nations, but in some form or the other, it has been in existence since pre-medieval times. The United Nations coined the term human rights. Let us look at the objectives of the United Nations as stipulated under the United Nations Charter. The United Nations Charter was framed in 1945. Let us read this slide together. To save future generations from war, to create an environment where all believe in human rights, to establish justice and respect for human rights, to promote social progress and better standards of living. Hence, human rights talks about peace, talks about justice, and talks about respect for everybody's human rights. It is also important to know that social progress and better standards of living are also included within the ambit of human rights. Bill of Rights. 4 of the initial United Nations instruments are contained in the Bill of Rights. Let us look at them one by one. Universal Declaration of Human Rights, or commonly called UDHR, has been adopted by General Assembly on 10 December 1948. Hence, 10th December every year is celebrated as Human Rights Day. Universal Declaration of Human Rights contains both civil and political rights as also economic, social, and cultural rights. International Covenant on Civil and Political Rights was adopted by the General Assembly on 16 December 1966. This covenant contains negative claim rights and first-generation human rights. International Covenant on Economic, Social and Cultural Rights was adopted by the General Assembly on 16 December 1966. You will see that the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights was adopted by the General Assembly on 16 December 1966. The Covenant on Economic, Social and Cultural Rights contain the second generation of human rights or the positive claim rights. The first optional protocol to the Covenant on Civil and Political Rights adopted by the General Assembly on 16/12/1966. This shows that both the conventions or covenants and the optional protocol was adopted on the same day. The first optional protocol allows an individual to communicate with the Human Rights Committee. The Human Rights Committee is the monitoring mechanism established under the International Covenant on Civil and Political Rights. It allows the ratification of or exceeding of the optional protocol allows an individual to communicate to the Human Rights Committee the violation of human rights committed by a state party to the International Covenant on Civil and Political Rights. Now let us see the definition of human rights as given by the Encyclopedia Britannica. Human rights entail both rights and obligations. States assume obligation and duties under international law to respect, to protect, and to fulfill human rights. The obligation to respect means that states must refrain from interfering with or curtailing the enjoyment of human rights. The obligation to protect requires states to protect individuals and groups against human rights abuses. The obligation to fulfill means that states must take positive action to facilitate the enjoyment of basic human rights. At the individual level, where we are entitled to our human rights, we should also respect the human rights of others. Hence, the concept of human rights also entails the concept of human duties. In the same way, we have certain human rights which we should be enjoying. The state has a duty to ensure and take steps that we are able to enjoy these rights. The duty of the state is twofold. One, to protect people from abuse of human rights. Two, to take steps to ensure that people's rights are fulfilled. Now we are going to look at certain categorization of human rights. The first categorization is negative claim rights and positive claim rights. What do we understand by positive claim rights? Positive claim rights are where the duty holder is required to act, to perform a particular task so as to ensure that people are able to claim such right. Who is the duty holder? The duty holder is the state. Hence, in a positive claim right, the state should do something. For example, if people are to enjoy the right to health, it is the responsibility of the state to establish and maintain public hospitals, to appoint doctors, and to ensure that the hospital is properly equipped. Only then can people enjoy their right to health. In the same way, to ensure people enjoy their right to education, the state should establish and maintain educational institutions, and these institutions should be equipped with proper infrastructure and human resources. Only then will a child be able to enjoy their right to education. Now, what is a negative claim right? In the negative claim right, the duty holder is merely required to desist from obstructing the enjoyment of a right claimed by the people. The state should not interfere. The state should not interfere in people's enjoyment of freedom of religion or freedom of speech and expression. The next categorization is the 4 generation of human rights. The first generation of human rights deals with civil and political rights. These rights are framed in the negative form, that is freedom from arbitrary arrest or detention, freedom from torture, freedom from slavery, freedom from non-discrimination. All these are contained under the first generation of human rights. In these generation of human rights, the state is supposed to shield people from abuse. The next generation, which is the second generation of human rights, this deals with economic, social, and cultural rights. They are framed in a positive form. Right to shelter, right to education, right to health, right to work. The second generation of human rights play a very important part in a welfarist and socialist state like India. Third generation of human rights deals with solidarity rights. To enjoy these rights, there has to be collective action on the global platform. For example, right to peace, right to a decent environment at the global level, all these fall under the third generation of human rights. Fourth generation of human rights is the implementation and communication of human rights. That is, the provisions of the Universal Declaration of Human Rights and the other United Nations human rights instruments should be implemented. People should be aware of them so that it becomes a reality for all. The last categorization of human rights is by content or substance, that is substance-wise categorization. For example, right to life, right to freedom, right to rule of law, right to liberty. Now, let us look at the history of human rights. Though human rights as a term was coined in 1945 with the birth of the United Nations, it has been there in different forms since the pre-medieval times. For example, the Magna Carta in England in 1215 provided for protection to people from arbitrary action of the king. In fact, Lord Dennings, who is a judge of the 20th century in England, he has been described as the greatest judge of the century, has described the Magna Carta as the greatest constitutional document of all times, the foundation of the freedom of the individual against the arbitrary authority of the despot. Now let us see the concept of human rights as contained under the United States Declaration of Independence 1776. By this declaration, certain states broke away from the British Crown. They have justified the breaking away from the British Crown on the ground of certain fundamental values being violated. What are these values? These values are reiterated in this slide. We hold these truths to be self-evident, that all men are treated equal, that they're endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is a right of the people to alter or to abolish it and to institute new government, laying its foundation on such principles and organizing its power in such form as to them shall seem most likely to effect their safety and happiness. So they reiterate the right to equality, the right to life, the right to liberty. It also goes on to say that those governing can only govern with the consent of the people, and that if the governing body does not abide with the human rights of the people, that governing body can be overthrown. It's the right of the people to overthrow a government which does not protect them. The French Declaration of the Rights of Man and the Citizen, 1789, is the basic document of the French Revolution. It also reiterates the principle of equality, liberty, freedom of speech, and freedom of religion. It goes on to say that all men are born and remain free and equal in rights. Now we are going to look at certain theories of human rights that will make us understand how human rights have evolved through different eras. Initially, there was the theory of divine rights. The kings and rulers traced their power to a divine being. They believed that they were representatives of God on earth, and they had divine powers to rule the people. Hence, what they said is what God was saying. The natural rights theory distanced itself from a divine being. The natural rights theory had a very fresh insight into the relationship between the state and the people. Aristotle and Stoics in the 3rd century BC spoke about the separation of God from human conduct. They said that human conduct should be based on logic and reason. It is not emotion, but objectivity with which people should face highs and lows that come to challenge them. Thomas Aquinas in the 13th century, an Italian, a doctor of the church, he said that certain behavior was naturally right because God ordained it to be so. What Aquinas said has been expanded by the other philosophers, especially those during the period of Enlightenment, different European philosophers. Hugo Grotius, a Dutchman from the 17th century, he said, it is not God, but humans who by right reason can identify what is right and wrong. He advocated that what is right and wrong is not what God says. It is what human, through their experience and understanding, know what is right and wrong. It is rational, reasonable behavior which is right. Thomas Hobbes of the 17th century, he also said that natural rights has nothing to do with God. It has something to do with reason, rationality, and objectiveness. He also said that people surrender their powers to the sovereign authority. The sovereign authority is hence supposed to protect the people. But Hobbes did not go any further. He did not know he did not say what people should do if the state failed to perform its duty of protecting the people, or if the state itself violated the rights of the people. This answer was given in the social contract theory, which furthered the natural rights theory. This theory states that the sovereign authority to whom people have surrendered their power, if it fails to protect the people, then people can overthrow that sovereign authority and bring another one in its place. In a democracy, a social contract theory is followed. If the government does not protect the interest of the people, in the next election, that government will be overthrown. Jean-Jacques Rousseau, 18th century French philosopher, he believed that inequality in society was thanks to the state. He believed that the state was not impartial, the state was not neutral. Hence, the laws which were enacted by the state protected a particular section of society, that is, the ruling class. Hence, he concluded that people should come together and collectively frame laws in the common interest of the people. This would not only ensure egalitarian laws being enacted, but it would also ensure that the laws are adhered to, because people would own the laws. Marx, the father of communism, has questioned the theory of human rights. He has an extremely different take on this theory. He believes the importance of human rights is its applicability, and he laments that the human rights has not achieved a social and economic just society. He said, human rights will only be looked upon as a successful concept if it is able to change the life of the most impoverished and the toiling masses. He also criticized human rights on the ground that they were very individualistic. Therefore, they were detrimental to community and societal interests. He further challenged the universality and inalienability of human rights. He stated that implementation of human rights in a particular country depended upon the inclination of the state. Hence, we cannot say that the human rights are universally applicable, and that several states have been known to deprive people of their human rights. But he hopes that the struggle for human rights will ensure reducing the gaps between the two classes of society. When we talk of law, we always believe that its end should be justice. But the legal positivist theory thinks otherwise. The legal positivist theory propounds that law is enacted by the sovereign authority. It has nothing to do with justice or injustice. Whatever be the law, the people are bound to follow them. People cannot break the law on the ground that it is unjust and leads to injustice. John Austin said that the existence of law is one thing, its merit and demerit another. Whether it be or not is one inquiry. Whether it be or not be comfortable to an assumed standard is a different inquiry. A law which actually exists is a law, though we happen to dislike it. What is Austin saying? Austin is saying that though an unjust law may be enacted by the government and people will have to be abide with it, the court can also always question it on the ground that it doesn't meet the acceptable standards. One could fairly argue that is the legal positive theory the result of grotesque, horrific laws which have been passed at certain times. For example, in Nazi Germany during World War II, or the apartheid laws in South Africa. The right to disobey the command of the state has been enunciated in the Nuremberg Principles. The Nuremberg Principles were framed after the Nuremberg trial. What was the Nuremberg trial? The Nuremberg trial was the prosecution of prominent members of Nazi leadership during World War II. At the end of the Nuremberg trial, the Nuremberg Principles were framed. The Nuremberg Principles defines war crimes. It also talks about taking preventive steps to ensure such a horrific situation does not arise again in future. Principle 4. The fact that a person acted pursuant to order of his government or of a superior does not relieve him from responsibility under international law, provided a moral choice was in fact possible to him. What this says is that often a person justifies his violation of human rights on the ground that he was commanded to do so. The Nuremberg Principle states that there is no need for that person to follow these commands. In fact, if he follows the commands, he will be as responsible as the commander. This is a United Nations instrument. It's a declaration on the right and responsibility of individual groups and organs of society to promote and protect universally recognized human rights and fundamental freedoms. This was adopted by the General Assembly in December 1988. Please read Article 10 closely. It states that no person shall act towards violating human rights and fundamental freedoms. Even if the state instructs them to do so, they are justified in not acting so. So, this first part of human rights, we have tried to understand the concept of human rights through different eras and its evolution to its current understanding. Thank you.